Hi friends, welcome back. Continuing with IBC, today I will be giving you a quick understanding of the procedure of initiating a CIRP process against a corporate debtor. Now, who can file an application with the NCLT for initiating a CIRP process against the corporate debtor? There are three of them: a financial creditor, an operational creditor, and a corporate debtor itself. So let us understand the procedure to be followed by each one of them for initiating a CIRP process. The first one is a financial creditor. The financial creditor, either himself or jointly with other financial creditors or any person on behalf of a financial creditor, can file an application with the NCLT for initiating a CIRP process in case of a default by the corporate debtor. Now, the financial creditor can file an application with the NCLT even if the default is with respect to some other financial creditor. And when I mention person on behalf of financial creditor, I mean to say the guardian of the financial creditor, an executor or administrative of the financial creditor, a trustee, or any person authorized by the board of directors of the company can file an application with the NCLT. The application also has to be forwarded to the registered office of the corporate debtor by registered post or speed post. Along with the application, the financial creditor has to submit a record of default or evidence of default to the NCLT and has to compulsorily propose the name of the resolution professional to act as an interim resolution professional. Now, once the application is received by the adjudicating authority, it will within 14 days ascertain the existence of default on the basis of the evidence furnished by the financial creditor, and where the adjudicating authority is satisfied that a default has occurred and the application is complete and there are no disciplinary proceedings pending against the proposed resolution professional, it will admit the application, and in case of the absence of any of the above requirements, it will reject the application. However, before rejecting the application, it will provide 7 days of time to the financial creditor to rectify the defects in the application, if any. And once the application is admitted by the adjudicating authority, the CIRP process commences. Now, the adjudicating authority shall communicate the order of admission or rejection within 7 days to the financial creditor or corporate debtor in case of admission, and to the financial creditor in case of rejection. Now, let us understand the procedure to be followed by an operational creditor to initiate a CIRP process. At first, the operational creditor, on the occurrence of default, has to send a demand notice and a copy of invoice to the corporate debtor demanding the payment of the unpaid operational debt. And on receipt of the demand notice and the copy of invoice, the corporate debtor has to within 10 days inform the operational creditor regarding a dispute about the debt and the pendency of suit or arbitration proceedings relating to the dispute, or has to inform the operational creditor regarding the payment of the operational debt by sending an attested copy of the record of the electronic transfer that it has made, or by sending an attested copy of the record of the check that has been encashed by the operational creditor. Now, if no reply is received, or no payment is received, or no notice of dispute is received by the corporate debtor within 10 days, the operational creditor can go ahead and file an application with the NCLT for initiating a CIRP process. Along with the application, the operational creditor has to submit the following documents. The operational creditor has to submit the demand notice and a copy of invoice, has to submit an affidavit that no notice of dispute has been received by the corporate debtor relating to the debt. Also, it has to submit a certificate from the financial institution that no payment is received by the corporate debtor, and also any other proof that no payment was received by the corporate debtor can be submitted. Now, along with the application, the operational creditor, not compulsorily but at its option, may propose the name of the resolution professional to act as an interim resolution professional. And if the adjudicating authority is satisfied that all the requirements of the applications are fulfilled, it shall within 14 days admit the application, and if it feels that if any of the requirements are not fulfilled, it may reject the application. However, it may provide 7 days to the operational creditor to rectify the defects in the application, if any. and once the application is admitted, the CIRP process commences. Lastly, let us understand the procedure to be followed by a corporate applicant to initiate a CIRP process. Now, where a corporate debtor has committed a default, a corporate applicant may file an application with the adjudicating authority to initiate a CIRP process. Now, when I say corporate applicant means the corporate debtor or a member or a partner of the corporate debtor who is authorized to make an application, or an individual who is in charge of managing the resources of the corporate debtor, or a person who has control over the financial affairs of the corporate debtor. These people may file an application with the adjudicating authority to initiate a CIRP process. Along with the application, the corporate applicant has to submit the following documents. It has to submit its books of accounts and such other documents that are relevant, and has to compulsorily propose the name of the resolution professional to act as an interim resolution professional. Now, along with the above two requirements, it has to submit a special resolution passed by the shareholders of the corporate debtor, or at least 3/4 of the partners of the corporate debtor, as the case may be, approving the application. And if the adjudicating authority is satisfied that the application is complete and there are no disciplinary proceedings against the proposed resolution professional, it will admit the application, else it will reject the application and provide 7 days of time to the corporate debtor to rectify the defects in the application, if any. And once the application is admitted, the corporate insolvency resolution process commences. So with this, I hope you understood the procedure to be followed to initiate a CIRP process by the financial creditor, operational creditor, and the corporate debtor itself. Thank you very much. Take care. Bye bye.